The FCA Test case, which is currently the subject of a leapfrog application for an appeal to the Supreme Court, has been widely reported. However, it is not the only recent judgment concerning business interruption insurance. And on the 15th of October 2020, the Commercial Court handed down judgment in the case of TKC London Ltd and Allianz Insurance plc. The judgment concerns Allianz's application for summary judgment and/or strikeout. Summary judgment is dealt with at Part 24 of the CPR, and the court may give summary judgment if the claimant has no real prospect of succeeding on the claim or issue at trial, and if there is no other compelling reason why the case should be disposed of at trial. CPR 3.4 subsection 2 gives the court power to strike out a statement of case if the claimant discloses no reasonable grounds for bringing the claim. In these proceedings, the claimant, TKC, operated a cafe restaurant in South Kensington in London. The restaurant was forced to close because of the UK government's coronavirus regulations in March 2020, and it did not reopen until the 4th of July 2020. TKC had a business interruption policy with Allianz. TKC made a claim on the policy and Allianz denied liability, so TKC issued proceedings in April 2020 seeking a declaration that the policy did provide an indemnity. After making Part 18 requests for further information, Allianz issued an application for summary judgment and/or strikeout in May 2020. The relevant clause of the policy covered business interruption caused by accidental loss or destruction of or damage to property insured. TKC had argued, amongst other things, that unexpected loss of use of the property as a result of the forced closure constituted loss to, alternatively loss of, property. TKC also argued, in the alternative, that loss of damage to stock in trade constituted damage to property. The stock in question was perishable food, such as dairy, meat and fish. Allianz argued that TKC had not suffered physical loss, but the temporary loss of use of the restaurant. Allianz argued that the temporary loss of use of the restaurant could not amount to loss of property under the terms of the policy. Though Allianz did not dispute that TKC had suffered loss of about £5,600 in respect of perishable stock, Allianz argued that any claim in respect of this was bound to fail at trial because the loss of stock did not cause interruption to the business. The business had already closed as a result of the coronavirus regulations. Furthermore, the policy required the damage to be accidental. The stock was never the subject of an accident, argued Allianz. It merely decayed and wasted away. The court found against TKC, dismissed the claim and entered judgment in Allianz's favour. The judge stated that lost property necessitated a physical loss and that TKC had only suffered a temporary inability to use the property. The judge also rejected TKC's argument about the stock, finding, amongst other things, that it was wholly unrealistic to argue that the deterioration of the stock was a cause of, and not a consequence of, the interruption to the business. The example clauses considered in the FCA Test case are concerned about whether a notifiable disease was present at or within close proximity of the relevant premises. There was no suggestion by TKC in this case that coronavirus had ever been present at the restaurant. What the judgment in TKC and Allianz makes clear is that an insured's temporary loss of use of a property can be clearly distinguished from an insured's loss of property.